I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
All right. Good morning, Miss Gill.
Good morning, Your Honor.
I wanted to bring you out because we're talking about you, and it's only fair that you get to hear what's transpiring since these are your cases.
Yes, sir.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Or, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay, good.
This hearing starts with chaos, accusation, and a defendant who clearly feels like nobody in the system is listening to her. And that is exactly why this case grabs your attention so fast. On paper, it begins as a fairly standard roadside-related charge, failure to stop and give information, meaning after a crash, the law says you do not just keep rolling, dodge accountability, or leave the other driver hanging while you go grab lunch. But within seconds, this hearing turns into something much bigger than a traffic-style allegation. Now we are talking about prior felony probation, an evading arrest case, a commercial driver's license, mental health concerns, public safety, and a judge who is very clearly not impressed with the defendant's attitude in court. What makes this hearing so dramatic is that there are really two stories unfolding at once. Story number one is the legal story. The state says the complainant was hit, followed the defendant for miles, confronted her for insurance, and then got hit again when the defendant allegedly backed up into her vehicle. If true, that is already serious. But story number two is the human story, and it is messy. The defendant tries to explain herself in emotional, fragmented bursts. She says she was hungry. She says she has been mistreated. She says she is struggling. She says she is a single mother. She says race is part of why she is being treated this way. And once that starts coming out in court, the hearing stops feeling like a simple probable cause moment and starts feeling like a pressure cooker. Now legally, probable cause is a low bar. This is not the stage where the court decides guilt or innocence beyond a reasonable doubt. The question is narrower. Is there enough here to keep the case moving? But what the judge does next is what makes this video worth watching. Because he is not just looking at the new allegation in isolation. He is looking at the defendant's history, her bond status, the risk to the public, and whether she can be trusted to follow court orders going forward. And when he starts talking about taking away her privilege to drive, especially after learning she is supposedly a commercial driver, the entire hearing shifts. So here is the big question for you before we even get started. Is this a case of someone overwhelmed, untreated, and unraveling under pressure? Or is this someone using every excuse in the book while putting other people at risk on the road? Watch closely, because the courtroom tension only gets sharper from here.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Road in Tarrant County, Texas, regarding an FHDI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallaceville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The
So
complainant,
are you telling me that now it was intentional?
the complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck the vehicle. The estimated damage from the complainant was around $4,000. and the defendant.
And this is where the hearing goes from serious to surreal. The allegation is already bad enough. A sideswipe, a refusal to stop, a confrontation over insurance, and then a second impact while trying to leave. But that line, that she did not stop because she was hungry and colored, instantly becomes the emotional lightning rod of the whole proceeding. Now, to be fair, the courtroom still has to separate explanation from excuse. Being stressed, upset, hungry, overwhelmed, or feeling discriminated against does not automatically erase a legal duty after a crash. If there is an accident, the obligation is simple: stop, identify yourself, exchange information, and do not escalate the scene. And let's talk about the legal posture here for a second. At probable cause, the judge is not deciding whether every allegation is proven beyond a reasonable doubt. He is deciding whether there is enough evidence for the case to move forward. And based on what has been read so far, 2 impacts, alleged refusal to exchange information, and estimated damage of around $4,000, that threshold is not hard to meet. The real danger for the defendant is what comes next. The judge is no longer just hearing about a single incident. He is starting to view this as part of a pattern. Once a judge thinks a defendant is ignoring rules, ignoring consequences, and potentially endangering the public, the conversation stops being about sympathy and starts being about control. So I want to ask you this. When someone gives a deeply emotional explanation in court, should that make the judge pause and dig deeper? If the facts still point to reckless behavior, is the judge right to stay laser-focused on public safety?
Stated she didn't stop because she was hungry and colored.
And what?
Colored.
Color.
Yes, Your Honor.
Can you look up to see if she has a valid Texas driver license?
Yes.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt.
After.
Finish.
I'm so
please.
sorry.
Finish.
I'm a commercial driver.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
This case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally. Because
Wow.
allegedly
Yeah.
hungry and covered. So now, this is an affidavit, and I hope that you take it seriously. Because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power.
This is the part where the judge sends a message, and it is not subtle. He has now found probable cause, But more importantly, he is imposing a very specific condition aimed at preventing what he sees as the immediate risk. Do not drive. That affidavit matters. A lot of viewers hear language like that and think it is just courtroom scolding. It is not. It is a direct court order, and violating it can trigger a contempt hearing, additional jail exposure, and even more legal trouble on top of the existing cases. In plain English, the judge is saying, I do not trust your judgment behind the wheel right now, and I am putting the force of the court behind that decision. And the CDL exchange makes the moment even more dramatic. Because if driving is tied to how she works, then this ruling hits more than convenience. It hits livelihood. But from the bench, that does not outweigh what the judge sees as a mounting public safety issue. He is looking at open cases, prior probation, a new allegation involving a vehicle, and a courtroom demeanor he interprets as defiant rather than remorseful. That is why the tone gets so hard, so fast. Now here's where it gets tricky. Defense lawyers often try to shift the judge's focus from punishment to stability, home ties, children, family support, treatment plans, mental health intervention. And those arguments matter. But they only land if the judge believes the defendant is reachable, manageable, and likely to follow orders. At this point in the hearing, the judge is clearly not convinced. So let me ask you, if someone says they are struggling and needs treatment, should the court lean harder into support, or is the judge right to draw a hard line when the alleged conduct involves danger on the road?
Power to protect my public at all costs. Do you understand?
I understand you, Your Honor.
May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. She has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she is willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what, Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, I mean, really,
Don't say it.
how many people died this weekend on the road because of the reckless and wanton actions? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping
don't say
me.
anything.
I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this. Okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children have trauma. okay? And I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point, your actions become your own,
You
right?
don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
I call out discrimination when I see it on a daily basis, ma'am. I don't care who it is. I don't care what color. If they're a small farm animal, I don't care. I call it when I see it. The only thing, because I don't know them. The way I get to know them is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes, really?
Officer Harris did not read me my rights.
Well, I will let
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
Yes.
She just brought me to jail.
You guys speak about that. I'll tell you, look, here's what I'm gonna do. I'm gonna leave your bond at $1,000 now. All right? I'm not gonna raise it to 5, but I can't continue to give you a PR bond.
Terminated from employment too.
Listen,
Okay.
do not drive. It's the only thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new
Yes,
case
sir. Yes, sir.
and just, all right. Come on. Justin.
And that is the full courtroom picture, not a final trial, not a conviction, but a very revealing bond and probable cause hearing where the judge had to balance compassion against public safety. The state laid out an allegation of failure to stop and give information, along with a second alleged impact after the initial crash. The defense pushed back with mitigation, family ties, children, mental health history, lack of medication, and a request for a more lenient bond outcome. The defendant herself made emotional statements about hardship, mistreatment, race, and feeling unheard. But in the end, the judge's ruling was driven by risk, prior felony probation, additional open cases, alleged reckless conduct involving a vehicle, and a courtroom presentation that he read as unstable and potentially dangerous. The most important legal takeaways are these. First, the judge found probable cause, which means the case continues. Second, he refused a personal bond and kept the bond at $1,000 rather than escalating it to $5,000, even though he seriously considered raising it. Third, he imposed a major condition. She is not to drive, and violating that order could create even more trouble through contempt proceedings. That is the broader implication here. Courts may consider mental health and personal hardship, but those factors do not override the bench duty to protect the public when the alleged facts involve danger on the road. But if you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.